నమస్తే. తెలుగు ప్రజల మనసాక్షి సాక్షి టీవీ. I am Swarna. Welcome to Sakshi TV special immigration show with attorney Prashanthi Reddy from the law office of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney and attorney Ms. Prashanthi Reddy, and on Friday at 6 p.m. with Banu Ilindra. Please tune in to ask your questions. If you have any queries regarding immigration, please feel free to call us. Our attorneys would like to answer your question. If you are immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or you can call us at 866-725-7441. Before we begin the show, please note down the information provided in the show is not a legal advice. It's for general information purposes only. Sakshi TV or its agents are not responsible for the use of this information. If you need any specific legal advice, please contact attorney directly. Today, we are going to talk about H1B frequently asked questions. For that, we have our attorney Prashanthi Reddy with us. Without any further delay, let's start our show by welcoming Ms. Prashanthi Reddy. Hello, Ms. Prashanthi Reddy. How are you? Welcome to the show.
I'm good, Swarna. How are you?
I'm good, thank you. Can you please provide us information on your law offices, practice area, and your experiences, please?
I practice immigration law and we're located in Midtown Manhattan. I have over 20 plus years of experience.
Awesome. So viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010, extension is 107, or you can email her at prashanthi@reddysq.com. So Ms. Reddy, so there's some of the questions I would like to ask you regarding like people who are living in US. So it's like I'm currently on 9th year extension of H1B. Is there any possibility to shift to different company? If yes, what is the procedure?
So the question is about, I guess, a H1 transfer in which the person has already used up 6 years of H1 and they're on their 9th year. So I'm presuming then, there's only certain ways of extending beyond 6 years. And the most common way of doing that is if you have an I-140 approved, then you can get 3 years of extension on your H1. But you can also leave the country for a year, and then when you come back, you can get an additional 6 years status, H1 status. So that's one way of doing it. Another way is by if you spend some time outside the country in your 6 years time, you can recapture that period. Another way is if your I-140s may not yet be approved, maybe it's pending, but it's been pending for over a year, or maybe you filed your labor cert and that is pending for more than 365 days. Then in that case, you can get a H1 extension, but only for 1 year. If your I-140 is approved, you can get it for 3 years. So in this case, this person wants to transfer. That means he's not extending with the same company, but he's going to a different company. And most probably he wants to use the I-140 approved from his present company. So a lot of people have that question as to whether they can use an I-140 approved from a different company, and what if they withdraw that I-140? Can they still, when you're transferring, obviously that previous employer is going to maybe withdraw that I-140. So they're worried about whether they can use that I-140 to file a transfer and get, the extension beyond 6 years. So that's, I think, the basis of the question. And yes, you can. Even if the I-140 is withdrawn, or even if the I-140 is filed by a different employer, an ex-employer, you can still use that I-140 to transfer your H1 to a new employer. Even if the I-140 is withdrawn, you can still use it for the 6-year extension period for those purposes. So there's some limited purposes for which you can use an I-140 even if it is withdrawn, and that is one of those the uses that is allowed even after I-140 is withdrawn. So to answer your question, yes, you can.
Okay. Before we go to the next question, we have a caller, Dilip Kumar from Virginia. Hello.
Namaste, madam. Prashanthi garu.
Namaste. Chappandi.
నాది నేను ఇక్కడ 2007లో మాస్టర్స్కి వచ్చానండి. నేను 2008 నుంచి అదే ఒకళ్ళకే పనిచేస్తున్నాను ఫ్రమ్ డే 1. నాకు 2014లో మా ఎంప్లాయర్ వాళ్ళ ఫ్రెండే నాకు గ్రీన్ కార్డ్ చేశారు. ఫర్ ఎగ్జాంపుల్
Okay.
నాకు ఎందుకంటే మా ఎంప్లాయర్ ప్రోగ్రెసివ్ ఎక్స్పీరియన్స్ యూజ్ చేసుకోలేము, అందుకని హీ రిఫర్ టు హిస్ ఫ్రెండ్స్ సో దట్ ఐ కెన్ దే కెన్ సబ్మిట్ ద ఎక్స్పీరియన్స్ లెటర్ అండ్ దే కెన్ ఫైల్ ఆన్ EB2 అని చెప్పి చేశారండి.
Sorry.
సో మొన్న ఏమైందంటే మొన్న October 2020 టైంలో వాళ్ళే మా ఎంప్లాయర్ వాళ్ళ ఫ్రెండ్ వాళ్ళే నాకు గ్రీన్ కార్డు 485 140 EB3 డౌన్ గ్రేడ్ అన్ని వాళ్ళే చేశారు.
Sorry.
ఆ ఎంప్లాయర్ కి నేను ఇప్పటిదాకా ఈ 13 years లో నేను వన్ సింగిల్ డే కూడా పనిచేయలేదండి.
Okay.
ఇప్పుడు ఏంటంటే నా క్వశ్చన్ ఫైనల్ గా ఇప్పుడు నేను పనిచేసే కంపెనీకి ఈ 485 అంటే 485J త్రూ ట్రాన్స్పోర్ట్ చేసుకోవచ్చా, పోర్ట్ చేసుకోవచ్చా, చేసుకోకూడదా? విచ్ ఐఎమ్ వర్కింగ్ ఫ్రమ్ లాస్ట్ 13 years.
So, ఇది అండి, you have to at least work for your the employer that filed your green card. You have to work. My suggestion is work for them for 6 months. After you finish working for them for 6 months, then you can port to another employer without working at all and never having worked. Port చేసుకుంటే, I mean, టెక్నికలీ పోర్ట్ చేసుకోవచ్చు, ఎందుకంటే 485 ఫైల్ చేసిన తర్వాత 6 months కి అకార్డింగ్ టు ద లా యూ కెన్ పోర్ట్ టు అ డిఫరెంట్ ఎంప్లాయర్ as long as the I-140 is approved and the job is similar. అది మనకు తెలిసిందే. కానీ ఈ సిచ్యువేషన్లో మీరు అసలు ఎప్పుడు కూడా ఆ ఎంప్లాయర్కి పనిచేయలేదు కదా. సో దే మైట్ బి అ క్వశ్చన్ ఆస్క్డ్ either at your citizenship interview, green card interview, 485 RFE. It can be asked in many ways as to whether you ever worked for the employer who's first petitioned you for a green card. So my suggestion, just to be on the safe side, is to work for that employer, get onto the payroll, for at least 6 months. And then after that, you do your porting. So that would be a better way to do it. Otherwise, the presumption is going to be that the employer that filed your green card never had a job for you and never intended to, hire you for that permanent position. So you don't want to be in that situation where the officer comes to that conclusion.
చూడండి. థ్యాంక్ యూ ప్రశాంతి గారు.
You're welcome. Good luck.
Awesome. So Ms. Prashanthi, we have another caller, Rakesh from Texas.
Okay.
Hello.
Hi Prashanthi garu. I'm Rakesh and
Hi,
I'm calling you from
Rakesh.
Texas. Hey, good. How
Yes,
are you?
Rakesh, how are you?
Great. So Prashanthi, my question is that see, I have been in US for a couple of years now, and I have been staying here for about 9 years. And in these 9 years, I have changed a couple of employers.
Okay.
So when I'm here, so I came here through employer A, then I have changed to employer B, and I have initiated my green card. And I had to leave that employer, and I stayed there for 6 months after my I-140 approval. So after that, when I shifted to employer C, employer B has, he revoked I-140. So my employer C has ported that employer B date, and then that particular I-140 is still alive, they have not revoked that. But after that, I have moved from employer C to D, and now D to E. So I have two questions here. As I'm in employer E right now, as I have already changed a couple of employers, my question is that will there be any problem for my green card? That is the first question. And the second question is that so if I move back from employer E to employer C, where my I-140 is still alive, where they have not revoked, so what is the process that employer C has to follow? These are my two questions, Prashanthi. I can repeat my question if in case you want
So,
me to.
Right. So basically, your present employer, you have an I-140 right now with the present employer?
No, I'm in company E right now, but my company C has my I-140 still alive. So
Right.
I'm
So
already with
you're saying,
five
is your
employers.
priority, if you can just answer my questions, is your priority date current? It is,
So
yes?
my priority date is like May 2014, and I'm in EB2. But I wanted to downgrade because dates are kind of moving ahead.
So you can do that, obviously with company E, you cannot do that because there's no I-140 with that. But you can do that through company C or D. Even the company D that has revoked your I-140, or rather withdrawn your I-140, can refile it. So or you can go with company C, where you have an I-140 approved and downgrade it. So it's the same thing, whether you go with C or D, because the one that's withdrawn can be refiled in EB3, or the one that's active can be downgraded to EB3. So either one you can go with, and it's the same processing time and the same. You just have to go with, I think, an employer there where you're more likely to get approved. There is obviously the issue of ability to pay because you are not on the payroll of either employer, and you haven't been for some time, and they want to see the ability to pay from the date of filing of the labor cert to present, which you won't have because unless the company is doing really well and has enough taxes to show profits in their taxes to show the ability to pay. So my suggestion is, of course, go with the employer that agrees to hire you, rehire you, but also go with that employer that has shows a lot of profits or net current assets in their tax return, because you are not on the payroll for all this time. Does that make sense?
Yeah, that makes sense. So my other question is that, as I was asking you, as I have changed like a couple of employers already, like will there be any problem with the green card processing? Do they give any kind of RFPs as such because of all these employers?
No, there's no rule that you should only work for 2 companies or 3 companies. There is no rule that you cannot file a H1 transfer as long as you worked legally and you never worked. You were never. You always had a H1 with the employer that you worked for. There is no rule that you cannot change, or you can only change certain number of times.
Got it. Perfect. This really helps, Prashanthi.
You're welcome.
Thank you so
Good
much.
luck.
So, Ms. Prashanthi, we have another caller, Mr. Vishnu from New York.
Okay.
Hello.
Hello.
Hi, Mr. Vishnu. Please go with your question.
Yeah. Hello, Prashanthi garu. My name is Vishnu. So my question was around basically I'm currently an OPT student. I'm on my OPT final year, and my OPT is about to expire. So my question was around what are the options we have, like generally, like what are the options that an OPT student has if he wanted to continue working for an employer generally, I would like to know what are the options available for an OPT student.
Well, you might already know the answer to these questions because you students are very smart and you do your research. So I'm sure you already know that you have STEM OPT if there is if you are studying in a STEM degree, then you have a possibility of filing for STEM extension. If you have already used up that STEM extension as well, then you know that you can file for a H1, provided that you get picked under the cap. And we know that not every, the chances of getting picked in the cap as of this year, it was 1 out of 4. So that's your chances of getting picked in a cap. And of course, if you have a master's degree, then you have more chances of getting picked because there's that additional 20% quota for master's degree holders. So your chances go up when compared to a bachelor's degree holder. And of course, a lot of people will continue to be in school and take one master's after the other because they try and they don't get picked in the cap. There's some people who try twice, thrice, then they go for another master's, and they if their school allows it, then they do a CPT. This is curricular practical training. Depending on whether the school curriculum requires it, then you could do a CPT and then work that way as well. There are a lot of universities that offer weekend or Friday, Saturday, Sunday courses and allow you to work the rest of the week. So that's a possibility as well, as long as you can show that, the university actually, the curriculum actually requires, practical training as well. So, I think that should answer your question.
Great.
Awesome.
Then,
So,
will it be wageable or will it be a regular lottery-based system in the upcoming year? Like, what's your prediction?
There was a proposal that they will do it based on wage levels, but they have withdrawn that proposal. So that is no longer on the table unless somebody brings it back on the table. It's still going to be lottery.
Okay. Yeah, sure, Prashanthi Garu. Thank you so much for helping me out. Thank you.
You're welcome.
awesome. So, Ms. Prashanthi, let's go back to our questions. So, this is another question I would like to ask. Like, after 6 years of H1B visa period, if someone is not eligible for the 6th year extension, what are their options? Like, can they switch to any F1 visa or some other status?
Yeah, so a lot of times we see that due to various circumstances, or maybe because people were busy, they don't start their green card processing on time. Or it could be that some MNCs don't file green cards. They don't want to file green cards for their employees. So it could be that situation as well. But they find themselves in a situation where they're on, the 5th year or 5.5 years are over on their H1, and they have not yet filed the green card. And so obviously then, since you cannot be on a green card on a H1, for more than 6 years, then they have to find an alternate. Either they have to leave the country, or they have to find an alternative means of working in this country. Or they have to stop working, and if they want to continue staying, then it really depends on what their plans are. So if they want to, if for example they have filed a green card but it's not yet, the I-140 is not yet approved, or 365 days has not passed since the time of starting the green card process, there is still 6 months, say, time left, but their H1 is expiring. For that 6 months period, they can switch status to, they can try to switch to a B2, a visitor's visa, and then switch back to a H1, or switch to an F1 and switch back to an F1 to a H1 once the I-140 gets approved, or 365 days has passed from the date of first filing of the labor cert. So it's like a stopgap, though. It's not ideal, but it's a stopgap measure where you're not leaving the country. But of course, you can't work unless you're on an F1 CPT. Then possibly you could work. The other option is to leave the country and then, do your work remotely if possible, and then come back, file a H1 and come back once your I-140 gets approved, or you qualify based on 365 days, getting over from the date of filing of your starting of the green card process. So either you have to leave or you have to switch to a different status. Those are the only options you have, really. If you don't have a green card pending at all, then you leave the country, you stay outside the country for a period of 1 year, and then, as I said, you can come back with a fresh 6 years of H1 period, 3 years and then 3 years extension. But then you fall under the cap, so then you have to apply for a H1 under the new lottery and then hope to get, selected under the lottery. So that's another way of doing it. Or you can come on a different status, such as on an L1 if you qualify, L1A or L1B, and you could work that way. And L1 is better for green card purposes because once you're on an L1, once you worked for at least a year as a multinational executive, you can apply for a green card directly for an I-140, and that's an EB1 category. So EB1 is current right now, unlike EB2 and EB3 for Indian nationals. So, these are the various things you could possibly do if you find yourself, your 6 years expiring. these are some alternatives.
Okay, thank you so much, Prashanthi, for answering my question. We have our caller, Shekhar from California. I'm Mr. Shekhar. Please go ahead with your question.
Sure, thank you. Hello, Prashanthi Reddy garu. My name is Shekhar. I actually did a downgrade for my EB2 to EB3, obviously in October time frame, and I've been waiting, and finally I applied for the premium processing for 140, and it got approved this week, basically yesterday. So do you, but the 765 or the 131, the case status shows as it is. There is no change. Like it says received on October 29th. What is the trend that you see, or how long it will take, or these two things are independent?
Maybe, it doesn't seem to be a uniform thing happening, because some people are, obviously a lot of people have received their AP EAD long time ago, and some people are still waiting. In some instances, they sent the AP EAD approval once the RFE was submitted. Sometimes they hold on until they issue an RFE. For example, if you don't submit medicals, then you know for sure that you're going to get an RFE. So they may not give the AP EAD until the RFE is issued, and then medicals are sent, and then they approve the AP EAD. But it's not consistent, and I don't know. Maybe some service centers are doing it and some are not. But I've seen that it's not consistent. In a lot of instances, even when we get an RFE and don't respond to it, while it's still pending, the AP EAD approvals come in. So I can't tell you that there is a uniform thing going on.
All right. So we have our next caller, Mr. Hari from North Carolina.
Hi, Prashanthi garu. Good evening.
Good evening.
Prashanthi garu, my priority date is August 2011, EB2 to EB3 downgrade, I-140 approved, medical supplied along with 485. My question is, till now I didn't get the biometrics. So if I don't get before September 30th, what is my situation after October 1st? Why I am asking, I am worrying that because next year only 10,000 for India GC visa number. So what is my situation, madam?
So again, you're asking me to predict what will happen, and no one can predict, right, as to what will happen with the visa numbers in October. We were expecting actually October will be really good because all the visa numbers have not been used for this year. So the EB3 dates for filing will be allowed, and things will become current. And it's same thing with final action dates. In your case, you care more about the final action date. And Charlie Oppenheim was saying that final action dates also will make rapid movement, forward movement. But now, because of the delay in USCIS processing cases, you will not be affected individually, but a lot of visa numbers will get wasted if they don't process cases by September 30th. But you will not get affected unless your numbers go back. The dates become again backlogged. But as per, I don't know, again, as per Charlie Oppenheim, if you watch his, he has a YouTube video, and he gives commentary on every visa bulletin. I think it's called Charlie Speaks. And he has basically been saying that he doesn't expect final action dates to retrogress until next year. So I think you still have some time, for this processing to complete, and I'm hoping, and USCIS is putting additional resources into processing cases that are current. So I'm hoping that they will get to your case and other cases like yours before, the dates retrogress.
When I can expect my GC, madam, this year or next year? Because August 2011 is my PD.
Yeah, nobody can say that. I can't tell you that.
But I can get it, right, by end of next year at least?
Oh, yeah, you should, because it's current. So unless it retrogresses, and I mean, they have said it won't retrogress because the demand is not as high as the the number of visas, because the consulates are closed and they're not in a lot of countries they are opened and closed, and family-based cases are not being processed with the same in the same way that they were processed in previous years. So all those numbers are falling into employment base. So you know that, right? The whole situation. So they don't expect a retrogress until this COVID situation normalizes, which they don't expect that to happen until next year. So I think we should be okay with retrogression shouldn't happen. Okay.
Yeah, thank you so much. Yeah.
Good luck. Good luck. Hopefully your case will get approved this year.
So Prashanthi, we have another caller, Mr. Suresh from Delaware. Hello, Mr. Suresh.
Hello.
Please go ahead with the question.
Yeah. Hello, Prashanthi Reddy. Hello.
Hi,
Good
Suresh.
evening, Andy. Yeah, hi.
Good evening.
Yeah. I filed my 485 Andy, and I filed my initially company A I shifted to three companies Andy. First, company A has initiated my GC process. I worked for them for around 9 years, and that company got merged to company B. And I worked for around 2.5 years with that company, and recently I changed it to a company C. And company B sponsored my 485, and they also did 485J and all those things. And I got an RFE on 485J and on 485J recently, saying that the employment address 485J law, whatever it is in labor, we kept that details and because that in that labor they didn't mention that I can work in different places or anything. That's how they created. They initiated initially in 2010. So for that we kept in 485J the address which is in labor. So now they did. Now they are asking us to show the any agreement over there for the employer who filed the 485 for me. So
what agreement? You mean lease?
Hello, Prashant.
Lease agreement? What agreement? What are they asking for?
They're asking for rental agreements. And is there a
lease?
Show us the rental agreement?
Yes. Right. Okay. So you're saying that that address is no longer valid? They don't have an office there?
Yes, ma'am. The company B is.
So they've moved. Moved. Have they moved to a different state or the same state?
They moved to a different state. They moved to a different state.
Then did you do an I-140? Then you don't qualify, right, for the 485 unless you can show that it's within the same metropolitan statistical area.
Okay. Is there any way where we can, recently they did my the I-140 to company B also. Recently they did that thing and it got approved. But in 485J we kept that whatever they mentioned in the labor.
Right, but at the time of filing, so then you should try and interfile your second I-140 with the existing 485, so that the 485 doesn't get denied.
Okay.
Because based on the J RFE, it will get denied, I think, because that company no longer exists within the same MSA. At least it has to be within commuting distance. It doesn't have to be MSA, but you have to argue that it is within commutable distance. If you can argue that, like if it's a neighboring state, about 50 miles, whatever, then that is a way of responding to such RFEs. But if it is in California and they move from New Jersey to California or something like that, then obviously it's not even within that 50-mile radius commuting distance. But if it is, then you can argue that. Otherwise, for the 485, they should be able to use any available I-140 as long as, you're working for that employer?
Right now, I'm not working for the employer B, ma'am. Right now, I shifted to company C, but the company B
Is your visa number still current? Can you file a
Yes,
new 485? Is it still current?
Yeah, it's still
Then you
current,
should
ma'am.
just make this argument, and then before your visa number retrogresses, file a new you can always file a second 485 using the other I-140. Get onto their payroll and do that before it retrogresses.
Okay.
If
So
that
you mean
argument
to say
doesn't work, so just keep that in mind.
Okay, got it, ma'am. Thank you very much, ma'am. Thanks.
Okay, you're welcome.
Awesome. So viewers, if you have any questions and would like to consult Ms. Prashanthi Reddy directly, you can call her at 212-354-1010. Extension is 107, or you can email her at prashanthi@reddy.sq.com. So, Ms. Reddy, is it possible for an H1B visa holders to start a firm in the US along with a citizen and then transfer their H1 to their company?
Yes, I wish that was possible. Then everybody would do that, right? You don't have to look for an employer. You could just start your own business. But H1, the requirements are very stringent. That there has to be an employer-employee relationship between you and your employer. So if you're owner of the company, even if you have another partner who's a US citizen, you're still part owner. So it'll be difficult to establish that employer-employee relationship even as per the regulation. But in real life also, the USCIS is never going to approve that petition because, even though they have cut back a little bit on that employer-employee right to control RFEs, in this situation where it's not a question of working for a third-party employer, but this is a situation in which it's really difficult to show the employer-employee relationship because you are actually an employer, you're not the employee. So it's difficult to show that if you have a partner that you are an employee of that partner, because you're not, you're part owner, right? You're a partner. So it might not work. It most probably won't work in that situation. The H1 will get denied.
Okay. So can someone apply for 2 H1B transfers at a time?
I don't see why not, but then they can't be in 2 statuses at the same time. So whichever H1 whichever H1 they file later, as per the last action rule, if they don't withdraw either of them, then the one that gets approved later will be the one that will finally become their status. That's something to keep in mind. So if you want to file both, then make sure you withdraw the one that you don't want to keep before it gets approved.
Thank you, Ms. Reddy. So viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010. Extension is 107, or you can email her at prashanthi@reddysq.com. So, Ms. Reddy, this one person, he's on like H1 or L1 visa now. Can they start some business on their own? Like, should they have to wait to get the GC to start a business here?
So again, the H1 is a very stringent non-immigrant visa, and it's very limited in its use. So you can only be on a H1 if you're working for the employer that filed that H1. You're not allowed to work for anyone else. It's not an EAD where you have the liberty of working for anyone, or where you have the liberty of working for 2 employers at the same time, unless you file 2 H1s, which are concurrent. So starting a business will not be allowed on a H1. You can always invest in a business, but investing and actively managing a business are 2 different things. Investing means that you're simply buying shares in Microsoft or in Amazon or whatever, which a lot of people do. You're allowed to do that, but you can't actively, for example, be a stockbroker and do that full time. You can't do that either. Neither can you work in open your own business and work for that. But if your spouse is on a H4 EAD, for example, your spouse can always, open her own business, because there's much more flexibility on a H4, on a EAD than there is for a H1, unfortunately.
Okay. So, Ms. Reddy, if someone has transferred their H1B visa to another company and worked with them for a few months, but not really happy with them, can they go back to their previous employer, like who has not cancelled their H1B visa?
Right, this is again a gray area, and different people will tell you different things, I think, based on who you ask, because USCIS has not defined this well enough. But I think if the H1 from the previous company is not withdrawn, and if you file the transfer to another company, then you can come back um, to the previous employer. It's an exception to the general rule where, like I told you, the last action rule previously, I told you that if whatever case you file the latest and if that gets approved, then that becomes your status. But I think this is one of those exceptions where even if your H1 is approved and you're not happy and you want to come back to the previous employer, you can do so by as long as the H1 was not withdrawn. So I think this is one of the exceptions to that rule. But generally you can't, because as per last action rule, whatever, if you ask for a benefit and and that benefit is granted to you, that your status is changed accordingly. You've asked for some change in status, it's been granted, your status automatically changes to that. But this is one of those exceptions.
Okay. So, viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010, extension is 107, or you can email her at prashanthi@reddysq.com. So, Ms. Reddy, if someone is planning to transfer their H1B visa to J1 visa, will they get 6 years of more of H1B after expiration of J1 visa?
No, people think that if they transfer their status to a different status and stay in a different status for 1 year, then they can get back the 6 years. There is no such rule. The only rule is that if you stay out of the country for 1 year, then you can get back status, not by filing a change of status and getting out of a H1 status for 1 year. There's no such rule. The rule is that you have to actually be physically out of the country for 1 year to get back that fresh period of 6 years. But as I mentioned, then you become subject to the cap, and you can only come back if you get selected in the cap. So that's something to keep in mind.
Okay. So if there is a person who is on L1 visa, but his H1B visa got approved, does the USCIS cancel their L1 status once the H1 visa is approved?
USCIS doesn't cancel anything. It's not their job to cancel anything. The employer is supposed to cancel, the previous ex-employer is supposed to cancel their I-797 petition if they are no longer working for them. That's an obligation that within 15 days, if a person is no longer working for you, if they were on H or L, non-immigrant work visas, then you're supposed to withdraw that petition within that stipulated time. That's an obligation that the employer needs to meet. USCIS is not under any obligation to cancel or withdraw anything.
Okay. So viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010, extension is 107, or you can send an email to her at prashanthi@reddysq.com. So, Ms. Reddy, if someone gets a new job recently and their employer has filed their H1B transfer petition, when they can start work legally?
So that's a good thing about H1 transfers. You don't have to wait for the actual approval. Even amendments, you don't have to wait for the actual approval. Once the petition is received by USCIS, you don't have to wait for the receipt either. Once the petition is received by USCIS and there's a confirmation of receipt, which could be as simple as a FedEx delivery receipt or used courier service. That's a confirmation of receipt, right? Once you have that confirmation, then the person can start working for the employer. But keep in mind, once you do that, the previous employer might cancel or withdraw their H1, and if you start working and the petition gets denied for some reason, then you fall out of status. So there is some risk involved in moving to a new employer even before it's approved. Instead, I would advise to file premium processing if possible, and then move once it's approved. So that way, there is no risk if your employer can wait.
Okay. So, Ms. Reddy, could you please advise us to how severe it is for an employer not to pay on bench for more than 30 days?
Right. So you cannot. There's no even 30 days period to not pay. You have every single day that the person is working, you have to pay. Now, even if the person is on a bench, that doesn't mean that they did not report to work. If you don't have work for them, then you withdraw the petition and you lay them off. But you cannot keep them as your employee and not pay them because they're not presently working. They are working. They're willing to report to your office, and they're willing to do any work you give them. So unless the beneficiary is not willing to work or is not able to work because of some personal circumstances, bench doesn't indicate that. Bench really indicates that the beneficiary is willing, but employer doesn't have work for them. So under that circumstances, you have to pay them for every single day that they're working. One thing you could do is file an amendment for part-time and thereby ask them to report to work only for part-time, and then your obligation, the amount of money that you have to pay reduces. There's less obligation on your part. So you can do that. And you can start paying part-time as soon as you file the petition. You're filing an amended petition, as I said earlier. Even in an amended petition, you can start working under the new circumstances as soon as the petition is received by USCIS. So in that situation, you file an amended petition for part-time, and at least you have to pay the part-time wages. But you cannot get away without paying anything. You have to pay. Unless it's not a bench and the employer has requested leave for personal or medical reasons.
Okay, awesome. So before we go to the next question, so viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010. On extension is 107, or you can email her at prashanthi@reddysq.com. So Ms. Reddy, can an H1B visa for a brand new company with $0 revenue be approved? How much does the revenue of the company affect the GC process?
Okay, so two different questions. So I'm going to take the first question. Does it matter what the revenue of the company is for a H1? No, it doesn't matter. Yes, you can have zero revenue and you can be a startup. The only requirement is that you, of course, have a proper setup. You have a bank's account, you have a proper office space, and you have all the licenses required to run a business. That's the only requirement, and that you have work for your employee who you're going to hire. You cannot say that I'm going to find work for them once I file the H1. You cannot do that. As of the date of filing the H1, you have to actually have work for them. So that's the only proof you need to show, that you have enough full-time work for that particular employee. But there's no requirement that you show that you have a certain bank balance, or you show that there's certain profits or sales that you have in the tax return. There's no financial requirement.
Okay. Ms. Reddy, we got a question from one of the viewers. I have an H1B visa from one company and I'm thinking to work for another company for 10 to 15 hours per week. Is it legal to work? Should I get any approval?
Yeah, in that situation, you have to basically file a concurrent H1, which means that you're not filing a transfer. You're filing an additional H1, which will be active along with your present H1. So you'll hold two H1s, one for full time, the other one as his requirement is for 15 to 20 hours. Absolutely, you can do that. But just make sure you're filing a concurrent H1 and you're not filing, any other type of H1. It has to be clearly marked in the I-129 form as concurrent. Then you can work, yes.
Okay, before we go to the next question, so viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010, extension is 107, or you can email her at prashanthi@reddysq.com. So Ms. Reddy, does an employer needs to continue to pay the required wage set forth in the LCA?
Yes, unless something has changed, and in that situation, then they have to file an amendment. So, for example, if the employment has changed, the number of hours have changed from full-time to part-time, then your obligation, obviously you don't want to pay full-time salary, but then you have to first file an amendment, get a new LCA, file the amendment, then you can adjust the salary accordingly. But without doing that, yes, you have to pay whatever the salary is on the LCA. The only way around that, if something changes, is to file an amendment. Then you can you can pay the wages as per the amended LCA.
Okay. So, is any employer required to pay the required wage if the employee is afflicted with COVID-19, consequently unstable to work and placed into isolation and quarantine during treatment?
So, you're asking me if the employer has to pay in that situation?
Yes. Yes.
So, as we discussed before, in a bench situation where the employer doesn't have work and the employee is willing to come to work, they have to pay. But in a situation where the employee is sick, right, and cannot come to work, then it becomes sick leave. In that situation, maybe you have to pay if you have a sick leave policy. If you don't have a sick leave policy, because you have to treat all your employees the same. So if you have that policy for some people, you have to have it for everyone. So if you don't have such a policy, or if they've used up whatever sick leave they have, then they can go on unpaid leave. So the employer doesn't have to pay in that situation. But if it's a situation where, and this is a little tricky, and I'm just presuming, I'm just going a step further and analyzing it. But in a situation where, for example, the employee is willing to work because he's maybe not that sick, but the employer doesn't want him to come to work because of the COVID infection. So in that situation, then what would you say? Would you say that in that situation, employer has to pay because he's not sick, he's willing to work? But there's obviously a COVID situation whereby he has to be quarantined. The employer wants him to be quarantined. So it's interesting to see in that situation whether the employer will be required to pay or not. Most probably they will be, because the employee is not asking for sick leave.
So, what are the steps that an employer has to take if it wants to convert an H1B employee from full-time to part-time status?
So same thing, like I said, you have to file an amended petition. So it is an I-129 petition that has to be filed along with all the supporting documents. So it's like filing a brand new petition. You have to show all the evidences of work. You have to file and get an LCA approved. You have to submit the degree copy. So it's like filing a new H1 petition, really. And the good thing is that you just have to file it, and then the person can work, for the different employer or whatever the purposes that you're filing the amended petition for. You don't have to wait for the approval to come. Filing and receipt of the application is sufficient, and the person can, work as per the amended LCA.
Okay. So viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010, extension is 107, or you can email her at prashanthi@reddysq.com. So Ms. Reddy, what steps does the employer have to take to terminate its obligation to pay the required wage?
Yeah, so as we discussed earlier, that the employer is always obligated to pay the wage, and the only way that they can become unobligated is, number one, if the employee requests leave, then they should have proof that the employee is not willing to come to work and has requested leave for whatever personal or medical reasons. So they have to have document that, and I suggest to document it in writing, not orally, because then there won't be any proof. Or if that is not the situation and the person doesn't actually have any work, then the person has to lay off. The employer has to lay off the employee. and laying off really means that they're obligated obviously to tell the employee that they're laying them off, obligated to inform them when the last day is and pay them the total wages or any back wages or any dues. They're obligated to pay that. And they're obligated to give them a return ticket back to their home country if they wish to go back to their home country. And they're obligated to withdraw the H1 if the person is no longer working for them. Inform the USCIS that that person is no longer working and ask for the 797 to be withdrawn. So these are the obligations of an employer if the employee is no longer working for them.
Okay, so what if an employee starts to work from home? What does the LCA requires in regarding to notice?
Regarding what? LCA regarding? Sorry, I didn't hear you.
It regards to notice.
Oh, notice. Okay. So there is this thing about the LCA notice period, right? Notice obligation. So you're supposed to post the LCA at the place, not only at your company location, but at the work location where the employee is actually working. So 2 places you have to post the LCA so that any other employees of yours can, look at it, and if they have any questions or they think that they have any questions, they can contact the Department of Labor or contact the employer. Because you're supposed to treat all employees equally, right? So if there's one software engineer making X amount of money, then you have another software engineer and the requirements are the same, then you have to pay them the same amount of money. So so to make sure that these obligations are met, they have these LCA posting requirements, and also they want the client now to be known. So that's another requirement that's on the LCA. So, but if the person is working from home, then obviously what is the work location? So I know it's ludicrous, but you have to post it on the refrigerator or the living room of the person's house. And there have been instances where FDNS has come for audits as well, and has looked at those postings which are in the employee's house. So I know it's silly, but we just have to follow what the rules are. So if the person is working remotely from home, then the posting has to be done in their house.
Awesome. So viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010. Extension is 107, or you can email her at prashanthi@reddysq.com. So Ms. Reddy, what are the main qualifications? Like, who can be under H1B visa occupancy?
So any person who has a bachelor's degree and a situation in which a bachelor's in a specific field is required for the job. To put it in other words, that any job that requires a minimum of a bachelor's degree in a specific field, and if, of course, the beneficiary has to have that bachelor's, then that person qualifies for a H1. So, for example, a doctor obviously qualifies for a H1 because the minimum requirement in the industry is a bachelor's degree in medicine, right? For a doctor. A lawyer qualifies for a H1 because the minimum requirement in the industry is a bachelor's degree in law. And it's a specific field. They're not saying a bachelor's degree in arts. A person with a BA cannot work as a lawyer. So it's specific. So in both those cases, those are clear examples of a person who qualifies for a H1. Now, there are situations in which it is not so clear-cut. So the employer might say that, I understand that the industry may not require a bachelor's degree, but I require a bachelor's degree. Okay. Because the duties are really complex. This is not, for example, if I say a programmer analyst, just to give an example, or a computer programmer. Maybe USCIS will argue that the industry in general doesn't require a bachelor's degree because people with an associate degree could qualify as a computer programmer. So then the employer can argue that the degrees that he is performing as a computer programmer, he is performing in a senior level, so he's a senior computer programmer, and the the duties are so complex that a degree is required, and this is he has to lay out the duties and the complexity of the duties and basically correlate the degree to the duties. So even then it's possible to get a bachelor's degree. But in general, it's, they look at industry standards.
Okay. So is there any minimum salary for a job in H1B visa status?
Yes, the salary is decided based on, you can either do your own private wage survey on industry, on what the industry says the standard is. So you can do a private wage survey, or most people tend to just look at the Department of Labor wage survey. So you can just use the DOL wage survey, and you can, so the obligation of the employer is to pay at least that salary or above that. But there's also another obligation that the employer has. The employer, as I said, has to pay the wage that he's paying the other employers, right, with the same qualifications. So it either has to be the higher of the two, either that or the LCA wage, the prevailing wage. So one of those two has to be paid, whichever is higher. Which means the actual wage, that's called the actual wage. The actual wage paid to other employees in his company who have the same qualifications and the same job. So it has to be either the actual wage or the prevailing wage, whichever is higher.
So Ms. Reddy, how long does it usually take to get H1B visa status?
Processing time can vary. Once you file the H1, processing time keeps changing, but now I think it's taking 4 or 5 months to get a H1 processed. But if you do premium processing by paying the 2,500, as per the new premium processing rules, the fee has increased, but the time also has increased. So it's now 30 days. Before it used to be 15 calendar days. You can get the case processed in 30 days, which really means that it could be an approval or it could be a request for further evidence that you get in those 30 days. So it's possible that you file premium processing, but you don't get the approval in 30 days. You get an RFE, and then you respond to that RFE, and they still process it expeditiously, but there is no 30-day calendar once you get an RFE. So something to keep in mind.
Okay.
And processing times keep changing. It could be 4 months, it could be 6 months, it could be just 2 or 3 months. Usually during the CAP season, because they have so many petitions filed at the same time, they take longer to process, and usually during other times they might take lesser time to process a H1.
Okay. So thank you so much, Prashanthi, for clarifying all the questions. Viewers, before we wind up, if you have any questions and would like to reach out Prashanthi Reddy directly, you can reach her at 212-354-1010. Extension is 107, or you can email her at prashanthi@reddysq.com. This is Swarna signing off. You're watching Telugu Prajala Sakshi TV. Namaste.